Bryan Kohberger's defense team filed a motion for change of venue. The prosecution won't budge. What do they say? Find out on this edition of About the Law.
Is it fair for the prosecution to not allow a change of venue? I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have intern Red as well as Yoli Medina, civil attorney, with us. How are you guys doing today?
Fine, thank you.
So last we heard, Kohberger's defense issued a motion for them to move venues because, as you can imagine, there's a lot of media publicity. There's a lot of stuff going on. But unsurprisingly, the prosecution has their own argument against this. Who would have been surprised? So, Andrew, let's go into a little bit of what we're talking about today.
Well, first of all, I want to say that I don't think you misspoke when you said it was the prosecution didn't want to allow a change of venue, because there have been all kinds of allegations that the judge and the prosecution are just a little bit too cozy. But let's remember, it is up to the judge. It is up to the court. So at this point now, we have a motion for change of venue from the defense, and the prosecution has now filed its opposition. And just the first thing that really took me aback was, Yoli, you can comment, anybody can comment, was that the defense memo was something like 319 pages with 4 experts. That if the prosecution comes back with, barely 21, 22 pages, including the technical stuff, no experts, and they're taking pot shots. Did I read that right?
You did. And I have a question for you, Andrew, because in California, we file exactly what you said, an opposition to a motion. Here they filed an objection, state's objection to defendant's motion to change venue. Now, I don't know why that is, if it's just terminology, but it's just they file objections to everything, like the objection to his motion, to his alibi notice. They file objections, and I'm not sure what the difference is, if there is a difference.
I don't think there's really a difference between an opposition and an objection. I don't know, but I want to approach this as though this was a paper that was submitted by the prosecutors, and we're going to grade it. We are going to give them a grade, but before we grade it, there need to be objective criteria. So we're going to take a look at 10 points within the state's objection to the defendant's motion to change venue, and we're going to look at those 10 points and see what they say. So the first thing we need to do is to bring it up on the screen. He says.
I got it.
There we go. All right, so this is it. State's objection to defendant's motion to change venue. I get bored by the people, the creators, to just read every word. It's an objection. That's what it is. And everybody knows that. We don't have to read that hereby and therefore and whereby, it is what it is. So, I just highlighted some of the language that just it's kind of an emotional thing. It's not really, I didn't see that this followed a format of, looking at the issues and comparing them to the law and coming up with a conclusion. There's a lot of emotional verbiage in here, like reverse engineer. The first point that I have is that the prosecution here is making a statement that has absolutely no basis. You and I talked before, Yoli, about how a lot of it is in the footnotes. And here's a statement they make where they accuse the defense of trying to reverse engineer a transfer to Ada County, which, according to defendant's own experts, has received the second highest amount of media coverage in the state, and where a statistically greater number, albeit slight, of the survey respondents, that's incorrect, by the way, familiar with the case, believe the defendant is guilty. Then after, noting the exhibits, hoping that nobody will read it, look at that, there's a little teeny tiny footnote, and we go down to the bottom and read this, and let's jump to the last sentence. Additionally, as the court is aware, this type of media, i.e. video bloggers on YouTube, true crime podcasts, true crime documentaries, and TikTok videos, is often the most inflammatory and prejudicial because it lacks the professional standards and safeguards of traditional media outlets, newspapers, and television. I'm really offended by that, because since when do the quote unquote traditional media outlets have anything resembling professional standards?
No, it's been a long time since I've seen that. That's why I got it to YouTube.
Pretty sure I actually saw that the news had put an AI generated video on their platform and said it was real. It was stupid. Like, it was just of a politician dancing, like somebody made it. But that's crazy. How did they not check that? You know?
That's a statement that is absolutely has no foundation in truth. There's no citation. He's making it up as he goes along. I've actually known people that worked in print, and I know a couple of newspapers where at some point back right around the 2000s, the first decade of the 2000s, they went in and they cleaned house and they got rid of a lot of their editorial people. So to say that the traditional media outlets have professional standards is just, silly.
They just wanted to give us a shout out. They're like bloggers on YouTube, true crime podcast.
Right.
Here
If
we are.
anything, like, at least on these kinds of platforms, they'll give you, like, maybe there's like a little note in the corner that says it might be fake news. Not the news, dude. Like, you don't even get that.
And to talk about professional standards in traditional media outlets, if you include Court TV, which I like, I love them. They bring stuff into my house and I can sit at home in the evening and watch trials. But at the same time, that particular outlet has run a couple of segments in a couple of different cases, including this one that said the case against Bryan Kohberger. And they had a token defense attorney for a couple of sound bites, but the whole thing was the case against Bryan Kohberger. So prosecution in Idaho, don't tell me about how the traditional media have professional standards, because those are gone. Maybe they were there when this isn't your grandfather's media. So,
Yeah.
All right, we beat that one to death. So next, here is a statement that they made that says that in determining whether pretrial publicity has risen to a level that justifies a change of venue, Idaho's appellate courts look to a series of factors, and then it lists 4 factors: accuracy of the pretrial publicity, extent to which articles are inflammatory, whether jurors are so incessantly exposed, and the amount of time between the crime and the trial. But look, they don't usually, when you list 3 factors or 5 factors or 4 factors, what follows is an analysis based on that. And I don't see that. Did you, Yoli?
I didn't either.
So
I didn't see
that's
an
number
analysis.
2. We're not doing so well on our grading. Number 3 would be over here on the change of venue usually only comes in the most extreme cases.
Right.
And if this isn't a really extreme case, I don't know what is. Do you?
No, this is the most extreme case I've ever seen.
This is the worst case scenario.
Yeah, especially when you had certain, news people or true crime news people saying that he stalked his neighbor and had a camera installed and was looking through the camera and rearranging her things. And I mean, there's no evidence of that.
So now there's 3 things we've looked at. And, they say that a change of venue should only be allowed in the most extreme cases. This is a case that has people watching around the world. I mean, Yuli, you're there in California. We're up here in New England. This happened in Little, Idaho. There is a YouTuber that we both know over the sea in London that talks about this case, if not every day, 7 days out of 6. I mean, so to say that a change of venue is only allowed in extreme cases, name me a more extreme case than this.
Right.
I hear crickets.
I feel like they're kind of like, I don't want to say overplaying the popularity of the case, because a lot of people know about it, but like also not a lot of people are interested in true crime. So like, I feel like they're trying to state that like, they wouldn't even matter if we changed the venue because everybody knows about it. But I guarantee you, if I walked up to like somebody who isn't on this podcast, they would not know what the Kohberger case was.
Yeah, I mean, ultimately, it's gonna be worse closer to where the crime happened. We've talked about it before, where it's like you have people talking to their neighbors, people wanting to sleep at night. It's like if it's not him, then they can't sleep peacefully. They have to believe that he's guilty. They don't have an option.
So the
Right.
fourth point that I see, anyhow, you guys can tell me what you see, but the fourth point is that this memorandum is shamelessly buttering up the judge to get on his good side and say, hey, judgy, you're doing a great job. And so, just leave it here where you can have full control. Look at this. Look at this. This case has nowhere near the chaos present in Shepard, a case that they go into here, and we've talked about in the past. As the Shepard court explained, the carnival atmosphere at trial could easily have been avoided since the courtroom and courthouse premises are subject to the control of the court. Now, this is an old case, a 1966 case. It was a huge nationally followed case, and cameras were relatively new. And in that case, it's true that there was chaos in the court because the court didn't know how to deal with the cameras. Of course, here we are, 50 years later, and here's where the your friendly prosecutor is buttering up the judge. Here, the court has scrupulously avoided such an environment. The court entered a non-dissemination order early in the case. Note the irony that the prosecutors noting this when it was the defense that first proposed the non-dissemination order. Not that the prosecutor didn't end up agreeing with it, but anyhow, when the small press pool that was allowed in the courtroom failed to follow the court's instructions as to filming or photographing the defendant, the court disallowed any media filming, photographing, or audio recording of court proceedings. This court has repeatedly taken precautions to avoid the circus-like environment described in the 50-year-old Shepard case, and thus Shepard is easily distinguishable in a poor comparison. So
Yeah.
they're saying, Judge, you're great. You're doing a good job, Mr. Judge. Just keep it up. Just keep it up. You can control this.
As we heard from that defense attorney we had on a couple of podcasts ago, he's going to be the judge if it changes venue. So he's still going to be in control of the courtroom.
Right. But what my point is just that they're saying, oh, Judgy Poo, you're doing such a great job. Okay, the next point that I wanted to make in this is number 5. There's a lot of conjecture here, and I don't know, Yoli, maybe you can explain this passage to me. This court must ask itself, and whenever I see language like this, I say, aha, I've just spotted an issue. But have I?
Yeah, well, the way this court must ask itself. No, I'm not.
Would an individual who was asked for their opinion about an upcoming jury trial continue a survey if they had no opinions about any upcoming jury trials? And once the survey started, would a prudent, thoughtful, and conscientious person who is reluctant to pass judgment with limited information opine to a stranger whether they believe a criminally accused is guilty of murder? Now, I know what he's trying to say, but that doesn't make any sense to me. Make some sense of this for me.
They're trying to get the court to question the validity of the surveys. That's the way I take it. If they had no opinions on any upcoming trials and they're asked for an opinion about this trial, how does that make it accurate? How does that make it accurate?
Yeah, I think what he's trying to say, but not well, I think what he's trying to say is that people that truly don't have a preconceived notion, people that don't have bias, people that don't have confirmation bias, those people aren't really going to, take part in the survey anyhow. And if they did, they wouldn't really want to take part in it. I don't know. This
kind of reminds me of when you have a homework assignment that's due in a few hours and you're just kind of trying to pull a bunch of reasons from every direction. It's like, well, Your Honor, really think about it. Are they going to take the survey if they don't think he's guilty?
Okay,
that may go toward their argument that Dr. Edelman didn't take into account people who refused to do the survey.
Right.
Right. And I don't.
So,
Go ahead.
oh, I was just gonna say, this is like, now I feel bad. But Mercury's in retrograde right now, and that makes like miscommunication common if you believe in astrology. That was nonsense. That's the only excuse I can think of for him.
That's like 3 times a year, if not more. Like every time Andrew's mad at his computer, I'm like, listen, Mercury's in retrograde.
Well, Mercury can't be in retrograde every day.
Well, like I had to read that a couple of times before. I mean, I think I understand it, but I'm not 100% sure. But I think that that's what they're trying to put this question in the judge's mind, that, you know,
that there are a lot of people that do not take part in surveys. I mean, I'm one of them. You call me on a survey, boom, I hang the phone up. So what he's trying to say is that is a statistically significant portion. He says that without any basis in fact or evidence. And so therefore, those who do take part are irrelevant. I think that's the point he's trying to make. But I don't think he made any better sense of it than anyone else, than Red did, calling it Mercury in retrograde. He should have just said that.
Mercury's in retrograde, so this motion may be difficult to understand.
Sorry about that.
Right. Well, no, you're making as much sense as this motion is. So then the next thing that stands out to me, and I think this is point 6, the court should also consider the fact that while the survey respondents were told that the poll was not political or sales related, these survey respondents were never told why they were being asked the questions. They had no way of knowing whether the poll was being done on behalf of the news media or a true crime blogger or for some other purpose. While they were told their responses would not be made public, they were never told whether they were being recorded. One only has to exercise common sense to see that there are innumerable reasons why prudent, thoughtful, deliberative, and conscientious individuals might hesitate to complete such a survey. Okay, that's fine. That's my writing in blue there. If the reasons are innumerable, why aren't any of them, not even one of them, named here?
Because they don't have an expert. That's the other thing, is that they don't have an expert to refute the defense's expert. So they're just making arguments, arguments that can be made, but arguments are not evidence. So I don't know exactly what they're trying to do. If they had their own expert point out the flaws in Dr. Edelman's survey, then that's evidence to contradict it. But they don't have that.
No, I agree. And that goes to what I said at the very beginning of our episode here. This is a 22-page opposition or objection. Now I forget which it is, an opposition or an objection. Let me get my thesaurus out. But anyhow, it's a 22-page objection, yet the Kohberger team had filed a memorandum in support of their motion to change venue of 319 pages. And that included their memorandum. But there were 4 experts, Yoli. There were 4 experts. There was Bryan Edelman, who is a PhD. There was James Murphy from True Scope. He provided a lot of information on the media. There was Scott Sunby. He is a capital murder expert at the University of Miami. And then there was, please forgive me if I don't pronounce this correctly, Amani El Alayi. He's a PhD social scientist. So from these 4 different views, kind of like our quad of panelists here, from 4 different views, they gave a reasoned, argument for why venue should be changed. And rather than coming up with their own experts, the state here, Bill Thompson, is just taking pot shots. And I guess that's usually what people accuse the defense of doing, is throwing enough mud up on the wall to see what sticks. So it's kind of interesting to see the roles reversed here. And I guess it's because, the burden is on the defense. If you file a motion for change of venue, you have the burden of proof. So I guess that's kind of why the roles are reversed. But it did kind of make my eyebrows go up a little bit, because we've known this was coming since what, January? I think they've been talking about it, change of venue, since January.
Mm-hmm.
And the hearing was then scheduled for May, and then they continued it from May until now. And notably, the deadline for filing this objection or opposition was May 12th, and they filed it right on the deadline, which tells me that they are like the kid in school who waits until the day before to write his paper.
Well, it kind of sucks, but also brings light to the fact that the prosecution is ethically obligated to try to just do their job well. It doesn't really matter whether or not they morally agree with it or not. It's just like, well, they have to file the objection. They have to do all this stuff. It isn't, it kind of points out the issues with court. It's just like, we don't even know whether they believe it one way or another. It's just, they're just taking the steps that they're expected to take as the prosecution, is the way that I perceive this.
Yeah.
But I'm not a legal expert, but that's just my perception of it.
Well, no, the 12 jurors are not going to be legal experts either. I mean, so, that's a valid point. And so, we have now taken a look at 6 factors, and we are going to give this opposition a final grade, but you're going to have to take a look at our final 4 reasons and our final grade for the prosecution in our next episode. Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.